Up next, we have Jennifer Zegel with the basics of digital asset planning. Jennifer, are you on the line?
Yes, I am. Hi, everyone. I hope you're all doing really well and staying safe and healthy during these novel times. Many thanks to Coin Genius for inviting me to speak today and putting on this fantastic conference. So thank you, thank you, thank you. For those of you who don't know me, I'm a partner at the law firm of Kleinbard, which is based in Philadelphia, Pennsylvania. And I am the head of the Estates and Trust Practice Group. So I focus my practice in the areas of estates and trust, and I also have a strong focus in business transactional law, particularly with a focus on succession planning. And over the last few years, I've developed a subspecialty in digital asset planning. I also launched a podcast, which is in its second season, called the Digital Planning Podcast, which I did with two other attorneys in the estates and trust space. And that's available on all major podcast outlets. So I hope you check it out if you like what you hear today. So we're going to discuss the basics of digital asset planning. We're going to talk about how digital assets are defined. We're going to talk about what needs to be addressed in both small business plans and individual estate plans, the current laws governing a fiduciary's access to digital assets, and some basic planning concepts. And when I talk about a fiduciary today, I'm talking about an agent under a power of attorney, or an executor, or an administrator of an estate, or a trustee of a trust. And my goal is that by the end of this lecture today, you're going to have a far greater appreciation for the need to plan in this area, especially in the light of how COVID-19 is really fast tracking the global digitization of data. So there are many aspects. I'm going to start my screen share here, so PowerPoint. In connection with digital asset planning. And the type of planning is really going to be varied depending on the type of digital asset owned and the security and accessibility concerns, in connection to that asset. And people have a lot of various opinions on what is secure or how things should be accessed, by when, and by whom. And planning in this area can be highly complex and also needs to be very, very customized. So we're going to start our journey today by discussing one of my favorite cases, which talks about a very significant crypto loss. And this is the estate of Matthew Melon. Now, Mr. Melon was one of the Melon Bank heirs, and he inherited a large trust from the Melon Bank family. And he was an early adopter in the cryptocurrency space, and he fell in love with the XRP coin on the Ripple network, which serves as a payment settlement system, specifically designed for financial institutions. And he invested early on in Ripple, about $2 million. And at that point, each coin was worth a fraction of a penny. So if you fast forward, from that point to December of 2017, at the height of the crypto market, his initial investment was worth hundreds and hundreds of millions of dollars. He cashed in, part of his investment at that point. And unfortunately, Mr. Melon was notorious for having some drug issues and mental health issues. And he became increasingly paranoid that hackers or other nefarious actors were trying to get him or trying to get his remaining cryptocurrency that he hadn't liquidated. So what he did was he took the private keys for the cryptocurrencies and he put them on various nano memory sticks, and he hid them in safe deposit boxes under alias names across the country. Fast forward to April of 2018, he was still having some issues with mental health issues, drug issues, and he decided to check himself into a rehab in Mexico. And on his way to the rehab, he died under mysterious circumstances. And he did not leave any known roadmap for locating the safe deposit boxes or unlocking the map to identify and secure and obtain these nano sticks that have significant, probably roughly around $300 million worth of cryptocurrency. And his estate is being probated in Los Angeles, California. Now, this is a very extreme example, but it shows and illustrates what can happen if there isn't a balanced plan in place. So here, Mr. Melon was very securely stored his crypto, but it was completely inaccessible and making it ultimately useless, unless it is obtained by his family. So the need for digital asset planning is only going to exponentially increase as our physical lives become more digitized. And this should really be a component of any estate plan, and especially plans for closely held businesses. Now, planning, as I mentioned, requires analyzing the types of digital assets owned and understanding what assets are capable of being transferred at a triggering event. And when I talk about a triggering event today, I'm really talking about somebody's sudden incapacity, mental incapacity, or their death. Now, not all digital assets can be transferred. Many people are under the misconception that their iTunes collection can be transferred upon death, but this is incorrect. Under the terms of service agreement, with Apple for iTunes and a lot of other Apple products, the user only has a lifetime license in the asset or interest. And once Apple finds out that somebody's gone, they're going to shut down those accounts, and there can be a lot of issues in connection with that. Other digital assets may not be subject to terms of service agreements at all. For instance, cryptocurrencies or digital art or digital property, collectibles, NFTs. And planning for those types of assets really focuses more on identification, storage, security, and accessibility considerations. Smart contracts can also present a lot of other nuances in connection with the plan, depending on the terms of the smart contract, the anticipated duration, and the rights and obligations owed, and whether there are any just jurisdictional laws that are governing the smart contract. And as this asset class, develops overall, planners really need to be more educated about the tech industry. And the tech industry really needs to know more about the legal issues and laws surrounding transfers at someone's incapacity or death, so that these assets can be properly documented and planned for. And of course, overlaying all of this is privacy, storage, and cybersecurity considerations. Now, generally reasons to plan for this asset class are to ensure that the asset can be transferred if it's capable of being transferred, and that it's transferred to the intended recipients. If assets aren't identified and inventoried, especially in the digital asset space, they can be almost impossible to discover, or their discovery or access could take an extended period of time. And depending on the type of asset, timing could be key. With cryptocurrencies, the market can be very volatile. There could be other rights and obligations that have timing considerations in connection with the digital asset that need to be taken into consideration. And if it's not properly documented, it could be almost impossible to find, or it could be cost a lot of money hiring forensic investigators, assuming there is legal access, which we'll talk about a little bit later on. Aside from a potential monetary loss, if these assets aren't properly planned for, there can also be a real sentimental loss. If you have pictures in a cloud sharing platform, there might not actually be accessibility to those pictures at a person's incapacity or death, depending on the terms of service agreements and some other laws that we're going to talk about a little bit later on. And they may not have a monetary value, but they could have, very, very significant intrinsic value, sentimental value to the heirs and loved ones that are left behind. Business records could also be completely inaccessible if they're not properly planned for. And I'm really focusing on closely held corporations and small companies, not large conglomerates that have loads of departments and people and IT support that are documenting these types of assets. I'm very familiar with a case where a woman was a widow and her husband was a small business owner. And unfortunately, he maintained all of his business accounts on a personal Google account. And she was unable to access the Gmail account after his passing, and ultimately lost a couple $100,000 in receivables for the business because she couldn't get that type of information and go to the people who owed her husband business money. Likewise, I know another example of a woman whose husband died, and he was a collector of website domain names. But this wasn't properly documented, and during the estate administration period, one of the website domains expired and it wasn't renewed because they didn't know about it. Somebody else scooped up the domain name and then sold it for reportedly $1 million. I mean, that caused a direct economic loss to the estate. So it's really important, to identify these types of assets and incorporate them in estate plans. Of course, planning during life and at death also helps safeguard and reduces the risk of identity theft and other cyber crimes. So I've talked a lot about digital assets generally, so what is that really? There is no uniformly accepted definition of digital assets. And the definition can change on the authoritative resource being consulted. So for our purposes today, we're going to use the definition from the revised Uniform Fiduciary Access to Digital Assets Act. And I know that's a mouthful, and it commonly goes by RUFADA. And I personally think RUFADA sounds like a superhero or something like that. But RUFADA defines digital assets as an electronic record in which an individual has a right or an interest, and that term does not include an underlying asset or liability unless that asset or liability is itself an electronic record. And RUFADA defines an electronic record as meaning relating to technology, having electrical, digital, magnetic, wireless, optical, or other similar capabilities. And it was written, very broadly to address future technology. And RUFADA was promulgated by the Uniform Law Commission for model legislation that states could adopt to govern at the state level of fiduciaries' access to digital assets. Now, RUFADA only controls digital assets that are subject to terms of service agreements. Digital assets, generally speaking, are not your computers or your smartphones, your devices. Digital assets in this definition are all of the pieces of information, all of the data, online accounts that are maintained and managed through those devices, or generally speaking in the cloud. Those are the digital assets. So kind of expanding on the definition of digital assets, there's 5 main categories that are recognized right now. So, you have your electronic documents. This is documents stored on a digital device, in a cloud, software sharing platforms would incorporate electronic communications, and Dropbox and other types of file sharing platforms, emails, instant messages, and those types of communications. Then you have your social media accounts. This would be LinkedIn, Shutterfly, Snapchat, Instagram, TikTok. More of these types of platforms are being constantly created. And then you have your financial assets. This would incorporate cryptocurrencies, tokens, digital devices and accounts maintained and online that are connecting to financial accounts or information, tokens, PayPal, Venmo, eBay accounts, and anything else really associated with a monetary value. This also could incorporate smart contracts. They may also fall into the next category, which would be business accounts and interests. Now, this would be customer information stored in digital form, databases, trademarks, websites, domain names, copyrights, anything electronically stored for a company. And as companies are moving towards becoming online, especially in the wake of COVID, almost anything connected to a business, could really be a digital asset. And of course, that could also include smart contracts or other rights or obligations with blockchain interests. And then you have your kind of miscellaneous category. This would include online gaming, airline miles, loyalty programs and points, YouTube accounts, pictures, videos, hologram likenesses, AI technology stored on smart property, the Internet of Things, NFTs could fall into this category. And this is constantly evolving. So these types of categories could be very different in a year, 2 years, 5 years down the line. Little joke for you. So now let's move into discussing some of the general laws governing digital assets in connection with the fiduciary's access. So you have the Electronic Communications Privacy Act, which includes the Stored Communications Act. You have the Computer Fraud Abuse Act and RUFADA, and of course, terms of service agreements. So the Electronic Communication Privacy Act really protects privacy and restricts accessibility to contents of files stored by service providers and records held about subscribers. There's some exceptions, but generally speaking, it prohibits the knowingly divulging of the contents of communications that are in electronic storage. Now, this law is silent on whether a fiduciary would have the right to access a subscriber's information at a triggering event. The Computer Fraud and Abuse Act similarly penalizes people who access computers and data without proper authorization from the user. Now, most states have adopted similar versions of these 2 federal laws, and the Computer Fraud and Abuse Act and many state adoptions of these types of acts don't address whether a fiduciary has access, because the access is silent under these laws. Now, both of these laws were drafted back in the 1980s, and they're completely inadequate to address a lot of the emerging needs, and especially as technology advances. So RUFADA was promulgated by the Uniform Law Commission in an effort to fill some of the gaps left by the two federal laws I just mentioned. Now, a version of RUFADA has been adopted in almost every state. And I'm in Philadelphia, I'm in Pennsylvania, and we're actually one of the only states that hasn't adopted a version of this law yet, although it is pending, and it could be within the next few weeks that Pennsylvania adopts it, which is very exciting. And again, the default rule under RUFADA is that consent to access digital assets by a fiduciary that are subject to terms of service agreements must be clearly established by the user through estate planning documents or an online tool. We're going to talk about what an online tool is in a minute. So RUFADA doesn't apply to tangible property like devices, and a fiduciary can lawfully access a decedent's phone or a computer, but the issue really comes into play, and it could be a violation of RUFADA if I'll give you an example, if a decedent's iPhone, anything on the local side of that iPhone could be accessed by the fiduciary. So if there's photos or information stored on the local side that doesn't require an internet to access, we're not going to have any problems with the fiduciary access. The issue really comes into play is if that phone is connecting to the internet and then it's connecting to different apps or accounts maintained by service providers. And that's where the issue really comes in, because that would be unlawful for a fiduciary to go into a decedent's email account through their phone, because it would be a prohibition of RUFADA. Under RUFADA, a fiduciary cannot impersonate a user. Now, and the fiduciary has to maintain the duties of care and loyalty and confidentiality, as you see in other physical, tangible assets, where fiduciaries have certain duties and requirements for their conduct. Now, RUFADA also doesn't grant more rights to a fiduciary that the user didn't have. So in connection with my iTunes example, a fiduciary isn't going to be given more rights under RUFADA. The user only had a lifetime license. So this doesn't expand any type of right that to the actual underlying asset. And this also doesn't apply to an employee's use of an employer's digital assets, because the employee has no other right to the asset other than what the employer has provided. And when an employee dies or is no longer working for the employer, that right is terminated. So there is no continuing right under RUFADA for employees' use of the employer's digital asset. Now, I'm sure you're all familiar with terms of service agreements, and they're agreements that control the relationship between a user and a custodian or service provider. Most of them prohibit password sharing, and they establish policies and procedures over accounts and assets. There was a study by the Queen Mary School of Law last year where they reviewed and analyzed a lot of terms of service agreements, and 85% of them don't address incapacity or death provisions, in the underlying terms of service agreements, which is very problematic. So I mentioned a new concept that RUFADA uses, which is called an online tool. Now, under RUFADA, an online tool is defined as an electronic service provided by a custodian that allows a user in a contract distinct from the terms of service agreement between the custodian and the user to provide direction for the disclosure or non-disclosure of digital assets and information to a third party. Now, an online tool only controls if the access is actually offered and utilized. And there are a lot of other nuances with custodian access that can still limit information even if there was an online tool utilized, but that's a topic for another day. I really look at online tools as being akin in some ways to a beneficiary designation, like a transfer on death account, but you have to be really, really careful. I mean, only 2 service providers are really utilizing this on their platforms right now. Facebook has a legacy contact page that you can, through their platform, designate who you would want to control your Facebook page after your passing. Google also has an inactive account manager through their platform, and you can specify, for all of your Google accounts and interests, from email to Google Hangouts to document sharing software, who would be the inactive account manager that would have access, or if those assets or accounts should be completely deleted when the inactive account manager would be triggered. Now, you have to be very careful though, because there's going to be a trend with service providers utilizing online tools. There are startup companies in the space now that are attempting to serve as a third-party online tool, and it's not quite clear if that will be respected. It's probably not respected now, but maybe as these laws evolve, there will be, a cottage industry developing for a third party to utilize and be an online tool for various service providers' accounts and digital assets. That's going to be evolving. But the bigger planning landscape with this is you have to be very careful. If you're going to use an online tool, you should have those designations very clearly identified in different digital asset inventories, which we'll talk about in a moment, because you could have a situation where you name one person, maybe unintentionally, to be, the contact under these online tools, but you have another person who would lawfully be, the administrator under a will if you don't have a will, or who you've named in your will to serve in that function. And if it's not aligned, or if it wasn't intentional to have different people, there could be a lot of issues. A lot of the things that have been talked about in this conference might not apply directly to Rufata, because some of the assets and interests with cryptocurrencies and blockchains are not subject to terms of service agreements. But the issue really comes into play is if private keys or other information are being stored in a platform that would be subject to a terms of service agreement. And so these issues and kind of the overall general landscape really need to be taken into consideration, because you may not be able to access it and get the information that wouldn't necessarily be subject to Rufata because of how it's stored. Now, Rufata also, has a hierarchy of access. So if an online tool is utilized, that is what the legal access is going to be first, whoever that person is, or whatever that direction is. It could be to delete the accounts. The next, if there is no online tool utilized, would be estate planning documents or other written records that are directly authorizing a fiduciary to access this type of information. And if there's no estate planning in place or other written record, then the terms of service agreements are going to be looked at, and that can be very problematic because the majority of them don't address these provisions. So let's move into some basic steps someone can take in connection with developing a digital asset plan. So the first step is really to inventory all of the digital assets and interests. And I really like clients to do it in separate inventories. So we'll have an inventory for all the different types of cryptocurrencies, and we'll talk specifically about what I like to include there a little bit later on. But generally speaking, they would have those types of assets, maybe some that are governed by Rufata on one list, and then you can have separate inventory lists for all the hardware, that somebody has acquired and all the software that they use. A big no-no in this area would be to have password information included with these types of inventory lists. Passwords that aren't subject to Rufata, they could be stored elsewhere, and it's more of a security and accessibility consideration. For assets that are interests that are governed by Rufata, password sharing is completely prohibited because it would be a violation of Rufata and the federal laws and impersonating a user. There's a lot of different schools of thought about the best way to manage inventory lists as well. The next step would be to explore whether any online tools, if they're available, have been utilized. What the designation is in those online tools. Is the asset being deleted? Who is the person designated? Is that person cohesive with the estate plan? And even if online tools are utilized, it's still very important to include provisions in a will, a power of attorney, and a trust agreement that either limit or expand a fiduciary's access to digital assets and designate the intended recipients and beneficiaries. Now, there's a lot of different types of digital asset clauses, but typically, you want to make sure you've established lawful consent. You want to address, whether the information is being disclosed, transferred, deleted. You want to define the digital asset, that is being discussed, or, provision for identification of that digital asset. And then you want to designate the ultimate recipients of those assets and information. Prenuptial and postnuptial agreements should also take into consideration digital asset clauses. Generally speaking, I've seen a lot of married couples who may share a Gmail account. Technically, that's not allowed under their terms of service agreements, but if they do that, who would have the right to have that Gmail account, or if they have digital assets, are they marital property? Are they separate interests? And those types of things should be begun to be fleshed out in pre and post-nuptial agreements as part of just overall planning. And then for small businesses, it's extremely important to incorporate, access provisions in the governing documents for a closely held business. There are a lot of different schools of thought with this, and especially for business owners. In my example that I discussed with the husband who ran his company through a personal Gmail account, that should also be cleared up. Is it a business account? What is in the business? Are tech management guides needed? I mean, these may not be legal documents, but even if you have established, clear legal access and the fiduciaries in, what does all of the business information mean? So a lot of times tech management guides are written with technologists and consult with a planner to make sure, everything is very clearly laid out and cohesive. And smart contracts can provide a whole other layer to the type of planning, because it's a good idea to have those types of contracts have plain language terms incorporated or as part of a digital asset plan, so they're clearly identified and the rights and obligations are known.
Jennifer, thank you so much. I'm going to have to go ahead and start transitioning. I'm not sure if you're completely done, but if you have any final thoughts, that would be great so we can get to the next breakout.
Okay, well, I do have more information, so if you want to follow me and learn more about digital asset planning, please follow the Digital Asset Planning podcast, which is available on all major platforms. But the biggest takeaway for all of this is it can be very, very complicated to properly address and incorporate digital asset planning into an estate plan, and it's not a one-size-fits-all approach. So thank you very much, and be well and stay safe, everyone.